This is the Bailed Out Podcast,
You have rights. Nobody knows how to deal with the bureaucracy.
where we talk bail to keep you out of jail.
The only thing that saved me each time is I wasn't drunk.
Does that mean you're a really bad driver then?
Hosted by Sean Plotkin, a multi-generational bail agent and 5-star author, and John Rorobar, a non-profit founder and attorney who has helped over 20,000 families.
We're not far right, we're not far left, we're very neutral, I hope.
Bail is the balance.
John, what is justice?
That is what the court system is there to establish.
Bailed Out is brought to you in part by searchandmate.com, Turning Leaf, and Angels Bail Bonds. Now, please welcome your hosts, Sean and John.
Hi there, this is the Bailed Out Podcast. I'm Sean Plotkin with my co-host John Rorobar, and today we're super excited to be having our good friend Joe Lombardo. He's a bail agent for a few decades and something of a surety expert. Today we're going to be talking about all of the bail people that are involved. What do we want to call that?
Yeah. There's a whole team with bail, and people sometimes don't realize what's really behind the scenes that make the system work. And so I wanted to go over the different characters that were in bail, the different roles that they play, and also try and work it through a case where a criminal process and be able to show you where bail fits into the overall criminal justice system.
Sounds great. Before we get into that, Joe, if you could explain a little bit about your history and experience, and we're super happy to have you here today.
Sure.
Yes, we are.
Thank you guys for having me. So I started my career in law enforcement and then found myself moving to the bail world. So I've been a licensed bail agent for 22 years, and I have some experience on the surety side of the business also.
Yeah, you grew up with bail agents.
I did. Several of my dad's friends, and I'm a second generation bondsman.
Ah, your father was a bondsman too. I didn't know that.
Yes, he still is.
Oh, still is?
Still is.
Oh,
Yep,
excellent.
Still is.
Is it possible, Joe, that you could elaborate for the audience what is surety, what it is?
So a surety company, the bail agents will contract with a surety company, and the surety company provides backing to the agency. They provide underwriting assistance, different services to help the bail agents.
And why do you think that the need of a surety has come about? I mean, either of you can expand on this. I'm sure you've...
Well, what the surety has is they have a certain form of security that they've had with the state to be allowed to be an insurance product. And it's that credit that they've established through the process of approval with the Department of Insurance that's really given to the courts as security for the amount of bail that the judge sets. So fundamentally, the contracting parties of a commercial bail bond are the state and the insurance company. That's the actual form that is signed. So they are the buck stops there. They're the responsible party.
Okay, so if we're going to be dealing, you had mentioned collateral. So for the audience, collateral is, in essence, skin in the game to be making sure that someone makes their appearance in court. The surety is the backstop with the county that's going to make sure that the defendant appears in court, or if not, that the county gets paid for their forfeiture or their failure to appear. Now, where do we want to go from here? What led into why we have sureties? And then it's...
Well, it all starts with a crime, right? That's really where the bail process starts. Is somebody believes a crime was committed, and that's investigated by the police, maybe immediately, maybe not. But then there's an arrest for the crimes that are serious enough, and someone is in custody. But it starts with the crime. I like to look at for these procedures the movie My Cousin Vinny. It actually lays out the criminal justice procedure better than any other popular media that I know. And of course, remember, it starts with a crime.
Or an allegation of a crime.
An allegation of a crime. Well, there is a crime, that has occurred. There's a dead body,
Yes.
right? There's a crime, and
The person could have just died on their own. We don't know that
with
they
the
got
gunshot,
murdered.
it could have been. It's possible, right? But there's a shot clerk. So then then there's an arrest and a process to determine who it was that committed the crime, and that's really what we're talking about here is what system do you have to be able to make sure that the state can properly investigate and prosecute crimes, and to give people an opportunity to prove their innocence of such charges, or that the nature of the charges are different. And for that, you need a process, and that's what bail provides, is the ability to have people out of custody while the state is still prosecuting to determine who committed the crime.
One quick question. Go ahead.
One thing about my cousin Vinny, though, is they did skip the bail process.
Well, exactly so, and they did
Which
that for an important reason.
goes with my question too. So I love that you asked that.
Exactly, for an important reason, because murder is often not bailable. There are different levels of crimes that you have, and bail affects that differently.
Or for a different reason, which I was thinking, perhaps it happened in a state that didn't have bail. There are some states that don't have bail, and there are some states that don't have sureties. Right?
There are some, but even those states that don't have bail or surety or available, they almost always have a surety process with the family, where somebody can place security. And whether or not they have commercial bail is less likely. Only the United States, most of our states in the Philippines have commercial bail, but the fundamental process of bail as security for the court that's forfeited if the defendant fails to appear is common in most states. But generally, it hasn't been allowed for murder since English times, or it's discretionary with a judge whether or not somebody with a murder charge, just because that if your life is on the line, you're more likely to run.
Absolutely. I think it's still a somewhat of an abstract concept with the role of a surety versus bail, and why the insurance companies are involved with that. I do want to get into more of what you're talking about with Cousin Vinny. But what states do not permit surety companies for bail?
So no commercial surety in Oregon, Kentucky, Wisconsin, and Illinois.
Right. But
in
for
Nebraska
instance,
or no? I think it maybe not in Nebraska too. Yeah.
Yeah.
But I got to go research that one.
But I know in Illinois, there's no commercial bail agents, but you still place 10% of the bond amount with the court, and the court essentially becomes the surety.
Or the full amount on riskier bonds.
Is that right? That I wasn't aware of. The federal government has another system as well, where essentially their federal pretrial agencies are the ones that secure the bonds with the family. They effectively take the place of a commercial bondsman, but they're government employees.
Well, and also on some federal bonds, there are surety companies that do federal bonds.
Yes, exactly. There are a few, but the terms of the federal bonds are generally not favorable to commercial sureties, and so they use them less in that context. And they use federal cases are much more technical, and there's many fewer of them. So having the government hire their own, exactly, they have, because they're bigger cases with and there's just less of them.
So the reason that I go back to the role of the surety specifically in commercial bail in the states that permit it is to stress the importance of the fact that what would happen, and I'm going to posit this, in California if we did not have surety companies.
Right.
What would happen with the defendants that are in jail?
Right. Yeah. So what they do now is they have government pretrial systems where where there are government employees that make recommendations to the judge for the kind of restrictions that somebody should have if they're going to be allowed out of custody during the trial. GPS, do they have to have home arrest? Do they have to have a scram device on their car?
Search and seizure.
Waive your search and seizure rights, right? So government pretrial really asks the question of, what
even
limitation should
I'm with you there. But even to extrapolate further my question, looking for the answer that I was looking for is, the bail amounts are very high in the state of California.
Right.
And if the judge chooses not to be allowing other ways, people would stay in custody because, one, they cannot afford to be paying the full amount of the bond, and or they cannot, they may not be released because of whatever reason through the pretrial release mechanisms.
Right.
So the role of the surety does help to be able to get the defendant out and be able to be back with the families.
Absolutely. And it's because of what I mentioned that the surety has established their credit with the state.
Yeah.
And so one of the rules is that the jail has to accept an admitted surety's bond. They don't have to be justified. Generally, if you're going to give something that's not cash to the court as a matter of security, the judge has to have a hearing to determine that that house or whatever security you're putting up is sufficient to cover the security for the bail. You don't have to go through that process with a surety bond.
So it's 3 a.m. Oh, go ahead.
I was going to just say, and absent a surety bond, when you're relying on the government pretrial programs, a lot of times with ankle monitors, search and seizures, you're subjecting yourself to elements that are reserved for post-conviction. And now you're taking a post-conviction element such as giving up your search and seizure rights and now forcing that upon someone pre-conviction when they have not been convicted of a crime.
Exactly so, and that's what I really like about bail is the nature of the decision that the bail agent makes is different. He's already got a relationship with the insurance company, and he decides, is this somebody who I'm willing to take a risk on?
Yes.
Because the bail agents are fully liable agents. So why don't you discuss that a
And
little
the bail agents then work with the families to get the person released from custody, ensure they make their court dates, help them with sometimes they need other types of help, and that's where the bail agent comes in and offers those services. And the person's not subjected to government control at that point while it's in a pre-trial, pre-conviction stage of the case.
So I've been doing, my dad did bail since I think 1973, and before him he was with Tico Maldonado, who started in 1958, and I've been going since 95, and I've never had it where a family goes and posts cash with the jail and gets out at 3 a.m. What have you ever? You've been a bail agent for it, and your father's been in it. Have you ever heard of it where people can just go post cash with the jail at any off hour and they'll let the person out?
Not in my experience. For a small bond, perhaps, but not when you get into the 10,000 and up.
I've had a few. I
have?
had a guy with
If you could elaborate, that would be great.
Bond that his boyfriend went to Central America, and we had to work that out. And you have to work with the family. I had a doctor years ago that had put up his house, and years after they had forfeited the house, I was able to find that the notice of forfeiture was insufficient, and able to get it, get the money back. So occasionally I have had that. I know in the federal system there.
Well, are you able to extrapolate a little bit further on that?
Sure,
and did it happen after hours where they went direct to the jail and they were able to put up the cash and the jail was willing to accept that? Because I'm thinking of is just the reason for the surety where they've already been agreed upon by the state where the jails have to accept the bond.
Right.
Well, to John's point, there's no justification. With cash, you have a cashier's check, let's say, that the jail wants to verify. 3 a.m, there's no ability to do so. If they're putting up property, there needs to be an appraisal done. There needs to be different things to check that the property qualifies. Whereas he said there's a justification that assumes the jail shall accept it.
Well, and that's the whole point of the question is to be demonstrating to the audience the role of the bail agency and the surety company that helps to expedite the release of the accused so that they can get back to their life or be able to get their attorney or be able to do things or not have an opportunity cost of missing work or not being there to take their children to school or having the shame of having to explain why they're not there.
Absolutely. The fastest release of all types of pretrial is absolutely commercial bail. And when you look at the numbers, it's substantially so, in the numbers that I've seen. Sometimes days faster on average.
And then to what you were saying about the pretrial release and what you were saying about how it could be almost post-conviction terms, part of the way to get a pretrial release is you have to answer a set of questions and have a certain, all right, check, this person qualifies. Well, in that process, you may be potentially putting yourself at a greater risk to be having contrarian stuff that you need to use in a defense against your charges. So if
Right.
everybody's like, oh, let's do pretrial release because it's great, well, you may have hampered your own defense. And then gone against the right not to incriminate yourself.
Yes.
So people, and I would argue that those that are for the bail reform are in some way on a spectrum against individual rights.
Well, and that really makes a lot of sense because it's just a very stressful time when you're arrested.
Yes.
And many people don't have that self-discipline to be quiet. And so you're in a scenario where you want someone to help you to be able to get out of custody, that the tendency is to want to offer more information to get yourself out of custody than would be wise.
Talk your way out of it.
Yeah,
Try
exactly.
to talk your way out of it.
And it just, most people, when they're in a scenario like that, they don't understand the patience required for the criminal justice system. They may get to a point where you get to tell your story, but that might be a year or several years from now if the case is going on. It's certainly going to be months from now before you ever tell that story. That right to remain silent is very, very powerful because you may not even know the story yet. You don't know what all the other dynamics are. So you lock yourself into a story that turns out to be wrong because of things you didn't know. Got to keep silent in the
you may believe that things happen the way that you saw them, but from a limited perspective, the narrative may be incorrect, and you could adversely subject yourself to be painted in a corner.
And I know people tell things to bail agents that they shouldn't, and just because it's at that time, but it's different than when you're telling a government agent.
It is.
The duties are different.
Absolutely. So recent, when I say recent, over the past few years, as bail agencies and the surety companies have tried to make bail easier on the general public, certain things that have happened were there used to be annual premiums.
Yeah.
And annual premiums were every year that there would be a charge to be going, not unlike an insurance policy where you pay a premium. But some of the actions by the bail agents and the surety companies is to remove annual premiums. I mean, have you, with your experience, have you, well, I'll move away from that unless you want to speak on it.
No, go ahead.
Yeah. And in many ways, surety is similar to a loan because it's the insurance company that's using their credit with the court, and that's what the premium is being paid for. It's a different dynamic. And so there were some insurance companies that would charge you for that security every year, per annum, they would call it. And others years ago had stopped doing that and were just charging one for no matter how long the criminal case takes. Because sometimes a criminal case, the complicated ones, will go on for many years.
Oh, yeah.
And so how long do you have access to the surety security? But now with the current legislation, you just have one premium for the entire time of the sureties agreed with that as well. It turned out where those renewal premiums were rare, and you just have to work that into your general business now.
Are there other aspects you think we can expand on the surety, or do we want to jump into the?
No, go ahead.
I think a good point, a good jumping point now is to get into when someone's arrested,
right?
And there's a bail set by the bail schedule, which says if someone is arrested for this crime, this shall be their bail until they see a judge. So
how do you know what crime they were arrested for? Who makes that decision?
The police officer.
Exactly.
So then for someone who chooses not to or can't make bail at the initial arrest, then you get into the complaint and the arraignment when there's within 48 hours, and that's when judicial review comes in.
Right. But I wanted to get a little bit more on that part that you had on the what are you arrested for, right? When there's a certain there's a call and the police come out, back to my cousin Vinny again, where they're arresting them for murder, right? But really the officer often doesn't know what happened. And there tends to be something like, especially in domestic violence, where the police will arrest and for a felony charge of a domestic violence, and you'll be remanded on that. But if a complaint is filed at all, it ends up being a misdemeanor that's filed. Nevertheless, The only information the jail has at the time of the arrest is the nature of the officer, what the police officer chose. And so the bail schedule is tied to the charge that the officer thinks that you violated.
Yes.
And to that point with the officer's charge, what about the vetting process? Is there some kind of detective or higher up official that makes sure that the charges make sense and then they pass it on? Or
next, right? If you want to get bailed out right away, you are stuck with the charges that the arresting officer had, because that process does take place to determine whether or not a complaint should be filed.
The reason I ask is because there's been a number of times where we go to post bond, and then they're like, "Oh wait, no, the defendant or this case needs to be under review to see what the charges are going to be," and sometimes the supervising officer determines, all right, well, no, let's let him be cited out. Or no, there's insufficient evidence to go with these charges. Or no, these charges actually became these charges. So from your experiences in that, please explain.
So there's an initial arrest. So the police officer makes the arrest. He writes a police report, books the person into jail. Bail is set at the bail schedule. That's generally what happens first. On the booking charge.
Yeah.
Then a detective reviews the case, and then a detective takes the case to the prosecutor to present for formal charges and the filing of the complaint.
Right. So they may, by the time you get to a defendant in jail, the detectives may be reviewing the charges, but you can still bail out on the booking charges generally.
So it's the part from the booking until the filing of the case and the arraignment that takes the longest. So that's where bail comes in, and it gives you a timely way to get out of jail if you so choose.
And this is why I was asking, because Joe has got some knowledge of sureties, but also a lot of knowledge in the criminal justice background. And as we're speaking to pretrial release, where you're saying things that could incriminate you, if a police officer has a charge in their mind and they're not released from jail yet, and then a detective may review it, perhaps what you say can add more charges prior to your release or change the charges. So it makes sense.
It could, but again, it's also a timely process. It takes time for pretrial to kick in. It's not going to be as fast as bail.
Right. Well, exactly. So pretrial, the detective's report, the other information about the defendant and the crime, the algorithms that they use are made into a report that's presented to the judge, which is generally a few days after the arrest, is when you would first go before a judge to have a bail setting process by the judge.
Correct.
I just want to reiterate, and I know that I keep backtracking to this, but we had a bail bond before where there was a fellow that was arrested with an allegation of shooting a weapon in the air, and then he unfortunately was a little bit loaded on some drugs and kept speaking to the jailer and to some of the staff. And as it happened while he was in custody, his bail got changed to attempted murder, and it ended up being a, I think it was upwards of a $350,000 bail, when initially we were looking at a 20 or a 30. So just to reiterate, if you're still listening out there, please keep your mouth shut when you're in jail, because what you say can and will be used against you.
Yes, absolutely. But that brings up another point, is that one of the processes in the booking is the defendant is going to be identified. And when he's identified, they check for other warrants. So sometimes, that booking charge is not the only thing that they find. If there's other warrants that are out there, if you had a bench warrant from another time, they're going to have a separate bail and a separate bail amount required for each one of those cases.
And then how would that affect somebody, let's say, so, and with warrants, it goes to the FBI database in Washington, D.C., and it's that can be a delay that will prevent people from getting released. So often customers come to me and say, "Hey, Sean, are you still asleep? Like, I posted bond 3 hours ago." And I'm like, rest assured, we're calling every 15 to 30 minutes, but we also don't want to anger the jailer, because I'm sorry, guys, I don't know why this is. We don't want to anger the jailer when we keep calling. And just to make sure, are we the only bail agency that's calling on your behalf? Because we don't want to have the jailer get bombarded with 5 or 6 other bail agents trying to get your loved one out, and then you're thinking that we just took your money and we're sitting asleep. No, there's a process that comes to it, and it's not just the jail itself. It goes all the way to Washington, D.C., and then the systems are down and the computers are down, and then sometimes jailers have shift changes, or maybe they're getting near their shift change and they don't want to deal with us. So I can understand that.
Staffing issues oftentimes.
Right. But every form of release will have those delays. Right, because the state needs to make sure who they have arrested, and there's a lot of people from all over the world. There are many people here in California that the system doesn't know.
Right.
They were born in Chechnya and came in through the Mexican border. They don't exist. That's going to take longer because the state has to fundamentally identify you before they can release you.
Or you have oftentimes people with warrants from out of state, and then they're held to see a judge. They're not able to bail out until they see a judge.
Exactly. Or you might have a parole violation or some of the probation violations. Sometimes those are easier now to get bailed out on, but sometimes the nature of the hold from another case won't let you get out of jail right away.
Yep.
What do you think? Are you able to speak relevantly to what some of the processes that the detectives would look at in what an officer would present for charges to be able to vet whether they would be able to be presented subsequently to the
so those are
court system?
The detective usually will compile supplemental information, witness interviews, maybe take a victim statement, things like that, and then the case is presented to the district attorney, who ultimately files the charges. The charges that are ultimately filed are up to the prosecutor.
Now, for the audience, keep in mind, once a bond is posted, a large part of the role of the bail agency is to be guaranteeing that you're going to have a release in court and to be getting you out of custody. We are default jailers in a sense where we are guaranteeing that you're going to be let out. To that point, there may be times, from what Joe had said, that the district attorney may choose not to prosecute. It's commonly known as a DA reject. And when DA rejects happen, let's go to the attorney and let him speak to this.
Yeah. So if there's an arrest and maybe the detective finds that it was the wrong person that was arrested, you've still been arrested, you've still posted a bail bond to get out as soon as you can, but instead of being prosecuted, the district attorney chooses not to, and you could call that a reject. Technically, if there was a crime committed, there's a statute of limitations where they could file those charges within years. But if you were released on a bail bond, there's a period of time from 15 to 90 days after your first appearance in court where you can keep on that original bond because the DA may just be delaying the charges. Yep. But after a certain period of time, if there's no charges that are filed, the bond becomes exonerated, released. The bond is over because it's not fair to keep people in custody without charges being filed. You have to for a period of time, but that time that you're out of custody, if you bailed out right away, there's no charges pending. Because the DA has yet to file the complaint.
And exonerated means that your liability to be appearing in court has been removed. Basically,
the bond contract is complete. That's our. I like that word, exonerate.
Yeah. Now, as I've come to understand it, and thank you for teaching me. I always love learning from John, and I'm learning some stuff with you here too. I always thought that it was approximately a year, but you're saying that the period that a DA could come back and file charges exceeds that? And what circumstances could that happen?
Well, most crimes have a 4-year statute of limitations. I had a bail agent with they got a case filed. It was a 5-year statute of limitations, and 4 years and 360 days later, charges were filed. So there's a separate statute of limitations that's different from the how long you can be held on a bond. So it's possible that you could post a bond, no charges were filed, and then 3 years later they could file the charges. That's within the state's ability.
Now, what would happen if there's a DA reject and the judge or the court does not formally exonerate the bond?
It becomes automatically exonerated either 15 to 90 days after the first appearance. The rule is it's 15 days, but if the prosecutor or the defendant asks for more time to remain on bail so they don't have to post a second bond, then they can extend it up to 90 days.
And this goes back to a 1304, like you were saying, or is that something different?
No, it's something different. It's in 1305A. It's just we had to have some limitation on how long a bond could be active without a complaint. And it was always 15 days from the date of the first appearance, but a few years ago they increased the flexibility by allowing the parties to increase that because, for instance, I remember a big case where the DA just didn't have the charges filed, but they wanted the person out on bail. They had to keep writing new bonds every 15 days in order to keep that bond active while no complaint was filed, because the DA sometimes don't want to file a complaint until they do more investigation.
Or you have a lot of times 15 days with workloads just not feasible. The DA can't get to all the cases. They're waiting for toxicology reports. They're waiting for more evidence. So I think 90 days is a reasonable time frame.
Right. But the first day starts at the first day to appear in court. That's the other real difference when you're released on bail versus if you stay in custody. If you're released on bail, your first appearance will generally be 6 weeks. With COVID, it was sometimes going out months and months before the first time you had to appear in court. And if you stay in custody, you have speedy trial rights where they have to take you in front of a judge and within like 48 hours to set the bail. Your access to the judge is much faster, but you are in custody.
So to that point, just to carry this out further, if the period that you need to, the DA needs to file is within 15 to 90 days of the first court date, what happens if the court date is unilaterally extended?
Yeah, it's the first court date. That's the first date set, the date set on the bond. It took me a while to get that established in the Court of Appeals, but because the language is a little weird, but it's it's the time for that period starts with the first appearance date on the bond.
So, okay. So audience, what I want you to be thinking about is if you had spent the money to get your loved one out of jail and posted a bond, you want to make sure that that bond's going to be going for as long as possible because you don't want to spend money again and again and again. So if you get a notice to appear in court, what happens, let's say, the 16th day or the 91st day? Does that mean that a new bond has to be done? Is it as black and white or is it subjective?
No, I mean it's 15 days after the date of arraignment unless you ask to continue it up to 90. So that's just the time for the DA to file the complaint.
And who's asking? So a defendant can unilaterally ask for an extension and then have that extended. But what if the court does it without the defendant asking for it?
Either the prosecutor or the defendant can ask for that extension, and the court's supposed to grant it. The court wants to grant those because they prefer to have the defendant out on bail, if the complaint is forthcoming. But the DAs know if they're working on the complaint or not. So often that 15 days is plenty. But if they are still working on it, they can get up to 90. But it's unfair at a certain point to hold somebody in the custody of a bail bondsman and to be able to be surrendered at any time when there's no criminal complaint filed. So there's just there has to be lines drawn somewhere. The courts thought that 15 days was too little. Too short. We didn't want to expand it the responsibilities of the bail agents if it wasn't necessary. So that was the last major change to the bail laws a few years ago.
So specifically on the 91st day, then they cannot extend it any further and a new bond is needed?
You need to do a new bond. Right. But you've got a few months before the first appearance. So if the DA hasn't filed a complaint in the 4 months that would take, that's a real rare event.
And then in what context would it make sense? So a bail rewrite is once why don't you explain a bail rewrite?
So a bail rewrite's when a new bond is posted for a defendant after the original bond's been discharged and there's no additional premium.
And in what context would a customer be eligible to apply for a bail rewrite?
I would say the most common one is what we're talking about when a DA files a case late. It's through no fault of the defendant. It was just there was a waiting period, and the 91st day came, and they filed on the 92nd day. That was no fault of the defendant. They weren't on the run. They weren't failing to appear, hiding from the bail agent. So oftentimes a bail agent will repost a bond for the customer.
And
Now, the tricky part about that is it has to be the same bail agent. If you go to a new bail agent, a new surety, they'll make you do a new bond. Those rewrites are with the same agent
but
and
then
the
again,
same surety.
that's where you see value added to using a bail agent,
Right.
and maintaining that relationship and getting to know the family and staying in touch. And
Right.
And then from a bail agent perspective, of course, if work had been done and then you're going to potentially have to go do other work, you also want to make sure that if you're a customer, and from a bail agent perspective, your where you're standing today could be different than 4 months from now, or 5 months, or 6 months. You may have moved, you may have become unemployed, or you may have gotten a better job, or gotten married, have a better support structure. So there is still some underwriting that could occur after a period of time, even though it's not a lot, to make sure that you're going to go to court.
You know, having a criminal charge filed against someone in your family is just a very stressful event, and most people lead their lives with a lot of stress as it is.
Yes.
And so, you know, typically the circumstances of a defendant and a family degrade during the criminal process just because it's an extra big thing to handle. So often it may need to be rewritten. You know, that's one of the risks the bail agents take that they're really good at evaluating is how stable is the defendant and the family to be able to make it through this criminal process.
So I think we've tended to hit some pretty good bases here today. Is there anything else we want to cover before we conclude?
Well, what did you learn today, Sean?
Well, I loved where Joe had helped to discuss what happens from the arrest and the charges, and I also liked that you had discussed a little bit more about what happens after the arrest and prior to your initial time to go to court. What did you learn today? Or what did you like about?
I liked being here. I thought it was fun. This is my first one, so I enjoyed it.
We enjoyed having you, Joe. This has been a good time for it. So I think we'll wrap here. Thank you so very much.
Thank you so much for listening to the Bailed Out podcast. Again, I'm Sean Plotkin, John Orba, Joe Lombardo. Why don't you sign, subscribe, listen, review, rate us on our Bailed Out podcast, and make sure to keep an eye out for Turning Leaf, Angels Bail Bonds, and SearchAndMate.com.